Hello everyone. Today I will talk on the subject of privity of contract. Privity of contract under English law. Privity of contract is a common law principle that a person cannot enforce the benefit of or be liable for any obligation under a contract to which he is not a party. The privity of contract rule defines that only the party to a contract can be able to acquire rights under the contract or has obligations imposed upon him under it, even if the contract was created to give that party a benefit. This is a key principle in English contract law and is applicable to all contracts where no rights are given under the Contracts Rights of Third Parties Act 1999. Contract defined. A contract is formed when an offer, consideration, and acceptance between two parties or more exist. A contract should contain six basic elements to make it enforceable. An offer in terms of a promise made by one party to another. For instance, the party will or will not do certain action in the future. Acceptance reflects the terms of the offer, like an expression through words or deeds which both parties agree. The evidence that both parties understand clearly and agree to the basic contents and substance of the contract. Consideration, which means something of value promised in exchange of doing or not doing something as defined in the offer. For example, the payment for works, services, or goods delivered. Each signatory to the contract has demonstrated the legal capacity to understand what they are signing. All contracts are subject to the laws of the jurisdiction under which these are executed. Types of contracts. Contracts are of two types. Unilateral contracts, which means promise made in exchange for a specific performance. Bilateral contracts is the promise exchanged for promise. There are further three types of contracts which are as follows. Sales agreements. These facilitate sales transactions and customer engagement. Non-disclosure agreements protect organizations' key assets, reputation, and business data. Service and vendor agreements are related to the business relationship with consultants, contractors, and other persons and entities. Original doctrine. The application of the law related to the original doctrine of privity was confirmed in the case of Weddell and Atkinson. In this case, parties to the contract clearly expressed their intentions to confer a benefit upon the third party. However, the court strictly adhered to the principle of privity and ruled that the requirement of a contract is a necessity, and further that consideration was not existed. So the claim was rejected. In Errington and Woods, the ratio explained that in a unilateral contract, there is an implied promise not to revoke the right once the performance of the act has commenced. This case lacked mutuality, still it was enforced. The rule enshrined in the doctrine of privity has been under criticism on the basis that it failed to give effect to the intentions of the parties, leading to unjust outcomes. In the case Dunlop pneumatic tire and Selfridge, Dew conceded to maintain Dunlop's price list. Dew and Co. resold the tires to Selfridge, maintaining the price list. Selfridge resold the tires on the price less than as indicated in Dunlop's price list. Dunlop sued Selfridge under the contract between Dew and Co. The court ruled that only a person who is party to a contract can sue under the contract. The law knows nothing of jus quaesitum terito, that is, a third party right of action arising by way of contract. By not permitting a third party's right of action, it will be an obstacle to enforce an agreement, and in the commercial transactions where a network of transactions exists with more than two parties to the contract. Due to prevention of Dunlop to enforce the contract on which he had relied upon, his expectations resulted in unfair outcome. This happened due to the privity doctrine, which obstructed commercial convenience. Shift from the original doctrine. In Beswick and Beswick, a contract was executed between Beswick and his nephew for a payment to be made to Mrs. Beswick for life. After the death of Beswick, the nephew stopped making payments to Mrs. Beswick. She sued him for compelling him to pay. The first court of instance decided to defend the privity rule that she could not receive the payment due to the fact that she was not party to the contract. The Court of Appeal and the House of Lords determined that she can sue as executor of her husband's estate and demonstrated a consumer welfarist approach in finding a just and fair outcome. At the same time, concurrently preserved the doctrine of privity. The House of Lords attempted to find justice for Mrs. Beswick in another capacity of law. Otherwise, the doctrine of privity would have permitted the nephew not to pay the payment for the business and had to take benefit by keeping it and be unjustly enriched. In Scruton and Midlands, a third party, the stevedores, tried to rely upon a limitation clause, which limited liability to $500 in a contract between the carrier and the claimant. The court decided that the stevedores could not be protected by the limitation clause because they were not privy to the contract. Lord Reed, in this case, commented that if a third party is able to establish that the employer is authorized to act on behalf of the third party as an agent, then the third party would get advantage of the exclusion or limitation clause subject to meeting a criteria. This reasoning demonstrated that to ease commercial convenience, a new category was recognized, for which the formal rules of offer and acceptance was not required to be applicable, despite the fact that it was not acknowledged in this case. New Zealand case law. In New Zealand Shipping Company and said that a third party negligently damaged goods. The third party had protection due to a statutory provision drafted in a complex way, namely the bill of lading in this case. The formal rule of offer and acceptance were applied. No communication existed concerning the offer and acceptance. The court determined that it was a unilateral contract. The act of unloading the goods by the stevedores provided good consideration. It was determined that the finding of a unilateral contract was, in principle, an attempt to force facts to fit unreasonably, uneasily into the offer and acceptance framework to establish a just and fair outcome. Lord Wilberforce stated clearly that privity should not be permitted to stop commercial convenience and demonstrated a realistic approach based on result oriented and underwritten by commercial convenience. The English law. Section 1 of the Contracts Rights of Third Parties Act 1999 provides a third party its own rights if the contract expressly permits for the third party to enforce rights and if the contract allows to benefit it, they can also enforce the rights. So this part of the act satisfies the problem which third party had with the common law, and thus cases such as the Beswick and Weddell and Atkinson, there it was established that it only party to the contract can sue was satisfied. The majority of firms use standard forms of contract when negotiating contracts, and it can be said that pursuant to Section 1 of the 1999 Act, a person not a party to the contract, that is, a third party, may in its own right enforce terms of the contract if according to Section 1A the contract expressly provides that it may. So the Act mitigates the need for complicated drafts simply by naming the person. A third party can take benefit itself and can enforce the rights. Section 2(1) of the Act provides that it has limited the flexibility of contracts for the reason that if a third party has communicated its consent, the contracting parties cannot vary or rescind the contract, which severely limits the power of the contracted parties. It has been provided that by allowing a third party to sue upon a contract to which it is not a party would lead to an indeterminate range of liability. And since the law requires certainty and predictability by allowing third parties right, it would make the law uncertain and unpredictable. Section 1A allows a third party to enforce a term of the contract where the contract expressly provides that he may. This has improved the situation such as Whittler Atkinson's because it gives effect to the intentions of the parties. Exceptions to privity. Collateral contracts and the sale of defective goods. A third party can initiate legal action against a seller or defective goods if the third party is affected by the defects in the goods. Agent. An agent may enter into a contract with another party on behalf of a principal where the principal may not be released on grounds of the privity as he was represented in the contract. Trust. An agreement between a trustee and another party may affect the owner. Restrictive agreement. A restrictive agreement may be enforceable against a third party where owner of a house sell to another person with the understanding that the buyers would not change the design of the house. If the buyer sells the house to a third party, the third party may be obligated to follow the original owner's conditions. Negligence. If a person injury resulted from negligence, the negligent party may generally be sued by third parties who are not parties to any contract with the negligent party. Assignment of the contract. Benefit from a contract may be assigned to another party. Insurance companies. A third party involved in an automobile accident with an insured vehicle may, in some cases, sue the insurance company when he gets a favorable court ruling against the vehicle owner. Thank you.